Are we ready to start with the extraditions?
Oh yeah, oh, they're here.
They're all here.
Sure, I don't have anything to do with this. We don't think.
Actually, I gotta wait for the clerk.
We don't have a clerk, and also, we don't have our BSO rep.
The first appearance, court. You are here because you have been detained on a warrant from another state. This morning, you will be asked whether you waive challenging the legality of your detention or whether you wish to fight the extradition to the state from which the warrant has been issued. And if you wish to waive the challenging of the extradition, you will sign a waiver extradition form. You have certain rights, and I'll read them to you. 1, while you don't have the right to be represented by court-appointed attorney this morning, you can be represented by an attorney of your choosing if you have hired one. You do not have to and should not say anything about the facts or circumstances of your case. Please keep in mind there is a court reporter or recording taking down everything that is said in here, and anything you say can and will be used against you in court. If you waive extradition, you will be held in custody until authorities from the state from which the warrant issued come to get you. Typically, that will be about 7 to 10 days. If the particular state hasn't picked you up in 30 days after you sign the waiver, we will release you from custody. If that happens, it doesn't mean the charges are dropped, but only that the other state waited too long to pick you up. The warrant will still be in the system, and you can be picked up again on the same warrant and held all over again. So the fastest way for you to get this matter out of your life is to waive extradition, go back to the originating state, and resolve the matter causing the warrant to be issued. However, you also have the right to fight your extradition to the state from which the warrant is issued. If you choose to fight it, the Florida prosecutors will advise the authorities in the other state that they have to start extradition proceedings for your return. And this involves various branches of government in the two states, including the governor's office. That process may take up to 2 or 3 months to complete. During that time, you will remain incarcerated here in Florida, and you will not be earning any credit for the time served while doing so. Again, I cannot give you any legal advice on if you should do so or on how long or how to go about it. So please let me know, do you choose to sign the form to waive fighting the extradition, or do you wish to take the 2 or 3 months to fight your extradition to the state from which the warrant is issued? Okay, so now I'm going to go through each case individually, and you could tell me what you'd like to do. Okay, I have Alexia Lawton. Okay, it appears that there's a violation of parole, and you'll be extradited to North Carolina. Do you wish to waive or not? You'd like to waive? Okay, we will give you the form so you could sign it. Okay? Tavis Jackson. Tavis, I'm sorry. Everybody deserves to have their name pronounced correctly. Okay, it appears, have a charge of possession of a controlled substance, and the other state is Georgia. Okay, so do you wish to waive or not? Okay. We'll get you the paperwork. Christopher Roddy. It appears there's an allegation you've failed to appear and a possession of a controlled substance. The other state is Tennessee. Do you wish to waive or not? Okay. We'll get you the paperwork. Sherry Schmidt. Okay. The charge is theft and the other state is Indiana. Do you wish to waive or not? Okay, we'll get you the paperwork. And Jennifer Brenner. The charge is theft and the other state is Indiana. Do you wish to waive or not? Okay. So that is, you want to waive? Okay. We will get you the paperwork as well. State, was there anything you wanted to add?
No, Your Honor.
Okay, so we're done?
As soon as they sign their waivers and.
The deputy is gonna take care of that, and we'll be done.
So, basically, I just might add that sometimes in other states, even though you sign a waiver, they may change their mind and say, we're not gonna come together. And if they do that, and we don't hold you, if you're otherwise ready to go. However, that's not result in that in other states. You get arrested again, you go to the same thing over and over again, you have to go back to that state and follow. They would have to prove whatever it is up there. Judge got it, or no judge down in Florida can resolve it. They couldn't want the system, they have to prove why they're prosecuting them.
I'm gonna say, that's okay, thank you.
I was told that the 30 days started when you get arrested. That wasn't true.
It starts when the judge signs the waiver. But for you, it won't start until you resolve your local.
Okay, then. Thank you. While we're waiting for the forms to be signed, we can move on to our other docket. I just want you to understand that you are all here for first appearance. All we do today is see if there is probable cause, and if there is probable cause, and I make that finding, then we will hear the issues to set your bond. There is no trial today. So, I want you to understand that the case isn't just going to get dismissed today because you tell us something, and everything you say is being recorded, and it could be used against you in either a motion or in a trial. So please do not tell me the facts of the case. Although I want to hear everything you have to tell me, it might hurt you in the long run. And your attorney will advise you of what's best for you. And if you have a question, please feel free to ask me. And we can get started now with Alicia Rose Moni Higgs.
In Paul Ryan, Judge. If we could call a case out of turn after this case, Your Honor. Thank
Of
you.
course. Okay, in Paul Ryan. We can't hear you.
I don't think they have her there.
Still
Well-
can't hear you, Deputy.
Is it maybe on our end, the speakers?
I'm there on Paul Ryan. Okay. Can you hear me? I can hear you.
You should be here in 5 minutes, sir.
Okay, we'll come back to you.
No problem, thank you, sir.
We could call Scott Galamidi on the second docket. He's at the Conte facility.
Is it on the 30, 40?
That's correct, Your Honor.
Galamidi, Scott Galamidi? Okay.
Good afternoon, Your Honor.
That's correct, Your Honor.
Which court?
Conte.
Conti, okay. All right, yes, sir. How are you today? Your lawyer is here, counsel?
Yes, sir.
That's
Good
correct.
morning. Good afternoon.
Javier Gonzalez here on behalf of Scott Galamidi. Scott, don't say anything. I'll go see you at the jail soon, okay?
Your Honor, this is a 30-day motion for release that counsel's filed. At this point in time, it's a 33rd day. The state has not filed an information. Your Honor, I'm going to be requesting a extension to the 40th day for cause pursuant to the rules of procedure. Your Honor, I'm relying upon Davis v. State out of the 4th DCA. Your Honor, the state has been unable to file an information due to backlog at the BSO drug lab. And through no fault of the state attorney's office, we are unable to file an information without confirmed drug lab results.
And, Your Honor, I'd be requesting my client's release. Today is the 33rd day. I understand that there may be a backlog at the crime lab, but the case that the counsel presented to Your Honor basically says that a backlog at the crime lab is not it's not an abuse of discretion if the court finds that good cause. The flip side to that is it wouldn't be an abuse of discretion to find that it isn't good cause and release my client. So that's what I'd be requesting, Your Honor.
And Your Honor, if I may, what I'm also, the other reason I'm making this request, and the 4th DCA is clear, what the court should take into consideration is the peculiar circumstances of each individual case. In this instance,
Thank you.
Your Honor, I'm providing the court with a copy of the probable cause affidavit. This is not a simple third-degree drug possession case. Mr. Galamidi is charged with a first-degree felony punishable by up to 30 years in state prison with a minimum mandatory prison sentence. Additionally, Mr. Galamidi has at least one prior conviction for drug trafficking. One moment, Judge. Yes, he was in 2011. He was placed on probation for trafficking an oxycodone over 28 grams, trafficking methamphetamine, trafficking butanediol, possession of diazepam, delivery of methamphetamine. He was placed on probation. He then violated his probation in 2014 when he was arrested and convicted of possession of methamphetamine with intent to sell or distribute. On each of those two cases, he was sentenced to 39 months in Florida State Prison. I believe, Your Honor, he has a prior trafficking out of Dade County as well. Considering the consequences he's facing, that he's before the court on a minimum mandatory prison sentence, Your Honor, the delay has not been caused by any inaction by the state. I do believe it would be appropriate to give the state an extension, a week-long extension to the 40 days.
And, Your Honor, if I may, with those priors in mind, I also would like to point out that he's never been accused of any violence towards the community. I don't think there's any failures to appear on his record. He always appears in court, so the concern about him being a potential flight risk, I think, could be alleviated, that even in those cases where he was facing serious charges, he still went to court and he's done his time. He may have those prior convictions on his record, Your Honor, but again, he's never failed to appear. So I don't think the court should be concerned with him being a flight risk.
Yeah, I don't think the issue is actually setting his bond at this point anyway. The question is, do I extend for 40 days or do I grant your motion to have him released?
That is the question, Your Honor.
So I am going to, based on the case law that they gave me, I don't find it to be the fault of the state, and I will grant the extra time to 40 days.
And Your Honor, and I spoke with counsel about this, and I've already prepared an order. He's actually will be pursuant to the case law. He's entitled to an automatic release if the state does not file an information by 5 o'clock on the 40th day, which is next Thursday, June 14th.
Okay.
That is correct, Your Honor. The order should state automatic release unless charges are filed.
I will look for it.
6/14.
It's right in there.
It's in there. Just want to make it clear for the record, Your Honor.
Thank you. All right.
Scott, sit tight. I'll go see you soon.
Okay.
Okay. You're here on Jackie Garcia, correct?
Judge, I'm here I have 3 MOs actually,
Okay.
but one of them is Jackie Garcia.
Okay. Can we do that one
Yes, Judge, please.
first?
I have her in North Broward.
Okay, there she is.
Good morning, sir.
Good morning. I do find I've reviewed the documents and I find probable cause. Okay, Mr. McLawrence?
Yes, Your Honor. Judge, from what I understand, this was a
And this is in my division.
It's in your division. This was a semi-self-surrender on Ms. Garcia. She or her boyfriend called the police and let them know that she had this outstanding warrant, so she turned herself in. Judge, I spoke with her earlier, and she indicated to me that she would like to resolve this matter so she could get on with her life. She does have a residence where she stays, and she's trying to find gainful employment.
Okay, and I will, do you know if she has any priors or?
I know I've represented her before on a previous MO, Your Honor, but as far as any other type of priors, I do not know.
And what were you looking for
Judge,
to resolve?
I was going to ask if the court is inclined, the court could either adjudicate in time served, or the court could withhold and take judicial notice of the time that she served.
Okay. All right. I will, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Do you understand English?
Yes, sir. Perfect.
How far did you go in school?
10th grade. I'm not quite finished, though.
Do you understand the charges?
Yes, sir.
And do you have any questions for Mr. McLawrence, your attorney?
No, we spoke just fine, sir. Thank you.
Okay, and do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
I understand that I was born here. Thank you.
Okay, I will sentence you after hearing everything to an adjudication court costs, credit for time served.
Thank you so much, sir.
Thank you. Good luck to you.
You too. Thank you, sir.
Thank you, Your Honor. Judge, I also have Joseph Curtis. He's on page 3 of the PM docket. He was reset from this morning, and he should be in the main jail, Judge.
Adjudication court costs. And while I'm looking, was there something you wanted to do on that case?
Yes, Judge. This was the gentleman that had the second case that was not on the docket. So we reset it so that the clerk's office could send the paperwork up on the second case. And I did speak to Ms. Tamu Davenport from the clerk's office, and she told me that she would provide the in-court clerk with the dispo on the second case, which is 182822 MO10A. And Judge, we were seeking to resolve both cases at the same time.
Okay, and you were looking for an adjudication court costs on both?
Yes, Your Honor.
Okay. Sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. Do you understand English?
Yes, I do.
How far did you go in school?
2 years of college.
Do you have any questions for your attorney?
No, sir.
Do you wish to enter a plea of no contest on both cases?
Yes, I would.
Then I will send you to an adjudication court costs on both cases.
Thank you.
Thank you. Have a great day.
Okay, you too. God bless you.
Judge, I think that's it. I think on page 3 of that same docket, Sean Hawker, I see a note that he bonded out. No, Sean Hawker on page 3. I just see a note that he bonded out. I'm just making sure. Okay, thank you.
Okay. And I'll just, please make sure the disposition for both cases are done before you leave, because I might be confusing. All right, Lorraine Rivera.
I think she posted bond.
Bonded? I did find probable cause.
You can recall Ms. Higgs if you would like to, Judge.
Okay, you had Miss Higgs, Alexia Rose Moni Higgs.
The deputy in Paul Ryan advised me that she is actually in her division courtroom today.
So what do you want to do?
We
It
can
is a
reset her for
capious.
tomorrow.
Okay.
I need my mom's number.
All right. Amerisha Janae Lovett. Okay. I see here that you were charged with reckless driving. And driving with a suspended license, child restraint required, another count of child restraint. Count 5 is a child restraint required. Count 6 is no safety belt, passenger under 18. And another count of a seatbelt violation under 18. And then there's a capias with a bond of $2,500. There's a division status on June 11th, 2018 at 1:30 p.m. I find probable cause. State, are there any priors or recommendations?
Your Honor, I'm asking that the bonds be kept in place. I'm showing that Ms. Lovett also, in addition to the charges before the court, has an open DWLS in county court right now.
Okay, counsel?
She's indicating she's going to be able to bond out, Judge.
Okay, then we will just leave all bonds the way they are, and I will, and she will bond out. Good luck to you, ma'am. The next person, Scott Clifton.
How you doing, Your Honor?
I'm great. How are you?
Doing good.
Okay, you are charged with a trespass. And state, does he have any priors or recommendations?
Your Honor, as far as Broward goes,
And was there an offer?
I'm really not in a position to make an offer because this involves someone's home, and according to the homeowner, this has been an ongoing issue.
Okay.
As far as his history, and I have not had any communication with this person. An 06 trafficking in hydrocodone over 28 grams, just under 60 months state prison, disorderly intoxication 05, theft 02, loitering and prowling, trespass, theft. Really my biggest concern at this point is him staying away from this woman's home, Your Honor.
Okay. And counsel, do you have any issues?
So she's indicated he wouldn't be able to afford the $25 bond or have anyone to bond him out, but he does have a valid address. I'd ask for pre-trial.
Okay, I am going to keep the bond at $25, and hopefully he can get this worked out at the division, since it was someone's home. And I will also require pretrial release with a GPS monitor if he does post the bond.
Your Honor, in light of the fact that Mr. Clifton is indigent, would the court consider waiving the $5 a day fee for the monitor?
Granted.
Thank you, Judge.
Okay, Kevin Daly. Kevin Daly. Good afternoon.
Good afternoon.
You are charged with a DUI, disobeying a lane control device, and a license not carried. I do find probable cause. State, are there any priors?
I'm not showing any Broward priors. I don't know if pretrial has any priors elsewhere. I don't know what the defense is seeking.
Counsel, did you have
He
it?
does have a valid address to live at. He's been in Broward County for 18 years, and the only source of income is disability. He does live with a spouse who owns a condo, who would hopefully be able to bond him out, but at this point hasn't been able to get in touch with him. He doesn't have any money in the bank. Would you be able to consider pretrial?
I have no objection to pretrial.
Okay, then I will ROR him, put him on pretrial.
And Your Honor, I would just ask for a condition of his pretrial be no alcohol or intoxicants.
That will be a condition, no alcohol, no intoxicants. Good luck, sir. Todd Fitzroy Booth. Okay, I've reviewed the documents. You are charged with trespass, and I do find probable cause. State, do you have any priors or recommendation?
Your Honor, I don't see any Broward priors. If he wants to resolve it, the offer would be a withhold court cost, no return.
Is your client interested in resolving his case? Which was the minimum offer.
Could the court advise what the court costs are, please?
$293,
I believe so, yes.
and I give him a year to pay.
He'd like to resolve, Judge.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down if you want. Do you understand English?
Yes, sir.
How far did you go in school?
Graduated high school with a 4.5 GPA.
That's awesome. Do you understand the charges?
Yes, sir.
Okay, would you like to plead no contest? If you want to plead not guilty, you're denying the charges, and I'll send you to the division where you'll have a trial. If you want to plead guilty, you're admitting to the charges. You'll resolve the case today. And if you plead no contest, you're not admitting or denying the charges, but you're telling me you will not contest the matter, and I'll sentence you today. So how would you like to plead?
No contest.
Okay. Do you understand? Do you have any questions for your attorney?
Not really.
Okay, and you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation.
Okay.
Do you understand that?
Yes, sir.
Okay, then I find you've made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and based on the documents in the file, I find a factual basis for the plea, and I'll sentence you to a withhold court costs, and I'll give you a year to pay. Okay? Good luck to you. Robert Lee Overman. Okay, sir, you have a capias issued against you in the amount of $500. You have a hearing in the division on June 12th, 2018. State, was there anything else to add?
No, Your Honor.
It's for resisting without violence.
If he wants to resolve it, the offer would be an adjudication time served on both counts. Yeah, just on adjudication time served.
Would you like to resolve that?
Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand English?
Yes, sir.
How far did you go in school?
I went to 10th grade, sir.
Do you understand the charges?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir.
Do you have any questions for your attorney?
No.
Do you understand if you're not a citizen of the United States, regardless whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. Based on the documents in the file, I find a factual basis for the plea. I'll sentence you to an adjudication court cost, credit for time served. Good luck to you. Dwandell Lavon Brown.
Does that been advice you hired Mr. Bill Gellman, private attorney?
Okay. So, if you have a seat, we'll give him a call in a few minutes at the end of the docket. See if we can get him. Okay, Kenneth Rashad Tillman. Okay, sir, you were charged with possession of cannabis, and you have a felony capias with a no bond hold. State, do you have any priors?
In light of the no bond hold, I'm not asking for any modification.
Okay, the bond is set for the possession of cannabis at $100. Did you have any argument?
No, not this time, Judge.
Okay, then I will set the bond at 100.
I didn't give me no mail.
Luis Antonio Hartu.
Bond is Judge.
Okay. Joseph Yeba. Okay, sir, you have a charge of a sexual assault over 18 years of age, a lewd and lascivious molestation. Count 3 is the same, lewd and lascivious, and count 4 is contributing to the delinquency of a minor. State, do you have any, and I do find probable cause.
Your Honor, on counts 1 and 2, those are both punishable by life offenses. Your Honor, I'm going to be seeking a no bond hold on each count upon a finding of proof evident or presumption great for first appearance purposes only, pursuant to State v. Isaza of the 4th DCA. Your Honor, I'm relying upon the probable cause affidavit for the court to make that determination and the evidence contained therein.
Counsel?
Your Honor, I reviewed the probable cause affidavit. In this case, we would be objecting to the court making a finding of proof evident presumption great at this time. Proof evident presumption great is the highest standard that we have in the criminal justice system, and what the court has reviewed is a probable cause affidavit that is designed to establish one thing and one thing only, and that is probable cause, which is one of the lowest standards that we have. So I would ask the court at this time to set bond for Mr. Yeba.
Okay, and what bond are you requesting?
I think Ms. Chase might be in a better position to answer that question than I am, Judge.
Your Honor, we're going to request that if the court is not inclined to find proof evident or presumption great, we would ask for 24 hours to perfect and not have a bond determination until that 24-hour period.
Okay, I don't know that you can perfect something like that.
I would be objecting to that, Your Honor.
Well, Your Honor, the state can always, if the court does not find that the state meets its burden, the state can always have an opportunity to present more evidence to meet its burden.
Okay, that's fine. Then I'm going to give you time to perfect. How much time do you want?
I'd ask for 24 hours, Your Honor.
I do find probable cause.
I understand.
I will give you 24 hours to perfect.
Thank you.
All right, so we're resetting Mr. Yeba for Saturday?
No, it'd be Friday.
Tomorrow's set, Friday.
Oh, you asked for 24 hours?
Yes.
Oh, okay, okay.
What would you like?
Yeah, I'm fine with PM, Your Honor.
All right, that is over defense's noted objection.
Okay. Alexander Raphael Wertheim.
Bond, Your Honor.
Okay, I did find probable cause too. Okay. Andrew Anthony Lopez.
Bonded.
Joseph Margiri.
He was here, Judge, if we can have a moment.
We can get back to him. Raymond Brave.
His bond posted, Judge.
Who posted?
I'm not sure, Judge. I spoke to him in the
No, what's the
beginning,
name of him?
Margiri.
Okay,
Yeah, he just bonded out.
okay. No, I went to the next name, so I was confused as to which defendant you were referring to. I'm sorry. Raymond Brave.
Bonded.
James Parker.
Bonded.
We heard that.
Michael Rocco Fanelli, or Fennell. I've reviewed the documents, probable cause affidavit. I do find probable cause. You were charged with possession of heroin, operating without a valid license, and driving on the wrong lane.
Finale.
State, does he have any priors?
I'm going to be relying upon pretrial, Your Honor. I don't believe he has any prior priors.
Okay, so there's no priors. Count And do you have a recommendation, State?
Your Honor, I guess it really depends on what the defense is requesting.
Well, the recommended bond is 1,000. Counsel?
Would the court consider standard pretrial for him to call in, or ROR?
Your Honor, I'm fine with pretrial, just no alcohol or intoxicants.
Okay, I'm going to ROR him. I'm going to put him on pretrial, and there will be no drugs, no alcohol, and random testing. Okay, thank you. Timothy Witherspoon.
Conti, Your Honor.
It's reset.
Okay. Sir, you've been charged with fleeing with disregard of safety. State, does he have any, I do find probable cause.
Your Honor, this is a change of charge. If I may approach.
Okay. Okay.
It's actually been upfiled. He was arrested for fleeing and eluding law enforcement, third-degree felony. That being said, I'm going to request that the court, even though it's been upfiled, I'm going to request that the court set the $1,000 bond that Judge Malika set originally back in place with pretrial GPS level 2 and no victim contact.
So you're asking for no change then?
I'm just
To
asking
the
for the
bond.
same bond. Yeah, same bond release.
Okay, counsel?
Judge, Mr. Witherspoon has a no bond hold for an out-of-county case. He also has $6,000 bonds on his other cases, so he needs to take care of those before he goes anywhere anyway. So he's going to need to go in front of his division judge. So $1,000 bond I don't think is unreasonable under those circumstances.
Okay, I'm going to keep the bond at 1,000. He'll also be released to pretrial release with the GPS, just like it was set up before. Okay? Good luck to you, sir.
Judge, I'm sorry, that means jail. If I may recall, Mr. Fennell, page 9. I'm sorry, the last one we did for Mr. Witherspoon.
Okay.
Judge, I'm going to ask that if there's a possibility I could have his son bond him out for the $1,000. So if he could have the order say either or for either bond out for the $1,000. If he's unable to make bond, then the pretrial.
Well, I ROR'd him.
Oh, you just ROR'd him? I thought Your Honor placed him on pretrial.
I put him on an ROR, and then I put him on pretrial.
All right.
I'm sorry, what?
Thank you.
Okay, so I can give you the order. Can we get back to that gentleman,
He's going to get picked up again?
He should be hoping, the computer says he's still physically here, so let's actually find him.
Okay. Counsel, we're going to go back to Joseph Margieri. You had mentioned that he bonded.
Is he in there?
Is he actually there?
Judge, he was here. I spoke to him earlier, but since then he's been removed. I think he's already gone.
Okay, I guess it's worked out.
Yeah.
Which is always good.
Judge, can we go back to Mr. the gentleman who had a private attorney?
Levon.
Mr. Brown.
Brown,
Yes.
Dwandell.
Page 6. I spoke with Mr. Jellin, Mr. Brown's attorney. He would like to know if he can appear by phone.
Sure, but can I do that at the end?
Oh, absolutely. I'll just call and let him know that the court is acceptable with that.
Okay, Jarvis Mack.
I'm advised he is in his division courtroom at this time.
Are you
The court
sure?
reset him tomorrow. That's what the jail told me.
I think he's just stood up.
No, that's the next gentleman, I think, Judge.
Oh, okay. So there's no Jarvis Mack there? Okay, so what do you want to do? Okay. And Eloah Moses Cannon? Elijah? Sorry.
He's president of Ninja, Judge. You could find the public defender's office.
And, Your Honor, I provided a copy of the affidavit to the arrest warrant so you can see what the allegations are.
Thank you. Sorry. Okay, sir. 1 second. Okay, and state, are there any priors or recommendations?
He's actually, Your Honor, he's being held right now, $25,000 bond on an aggravated assault on a law enforcement officer, $1,000 on attempting to elude law enforcement. He's got a no bond hold on, a court order no bond hold on 2 separate cases of grand theft. He's got $1,000 bonds on grand theft auto and passing forged title of motor vehicle. On the following charges, I'm going to request bond in the amount of $1,000 on the grand theft, $1,000 on the illegal use of credit cards. And I'm sorry, I know I'm not going in order probably in your findings. I'm going by what's in front of me. Yes. Who said him at no? But that's on the warrant, right? Or did the judge who said him at no bond? I know, but he's entitled to. If it's no bond pursuant to the arrest warrant, he's entitled to a bond.
Okay, anything else?
Your Honor, and because the burglary was of a home and occupied, I'm going to be requesting a $20,000 bond on that count.
And what about the grand theft?
$1,000, Your Honor.
Okay.
And obviously, no victim contact should he be released at some point.
And does he have any priors?
One moment, Judge. Your Honor, I could check to see if he had anything as a juvenile, as an adult, just the open felonies that I advised the court of.
Okay, sir, do you have a place to live?
Yes.
Okay, in South Florida?
Yes.
And how long have you lived in the place you're living now? Your last place of, your last address?
8 years.
Okay, and do you have family and friends who can help you with your bond?
Yes.
Okay, and do you have a job?
No.
Do you have any income at all?
Yes.
Okay, and do you have any assets?
No.
What is your income monthly?
1,000.
Okay. All right, well, based on the charges that were filed against you, I find probable cause. I am going to set the grand theft count 13 at $1,000, count 12 at $1,000, count 11 $1,000, count 10. I'll do it 20,000. No victim contact. If you're released. Good luck to you, sir. Okay, Amy Tedder. Did we want to go back on that?
Yes, Your Honor, she's in North Broward.
Amy Tedder.
Right here.
Okay, you were charged with a petty theft and a resisting officer with violence. I find probable cause. Counsel for the state.
Well, I believe Mr. Reedy was going to see if he could get some information to update the court.
Yes, that is correct, Judge. I did speak with one of the program directors at Destination Hope to inquire if Ms. Tedder was welcome to come back there, and their answer was no. So she does not have a place to go at this time. I would ask, she doesn't have any money at this time either. I would ask the court to consider pretrial release or a low bond. I know that the court found probable cause, but I mean, a reading of this probable cause affidavit, I think, indicates that Ms. Tedder might have been not thinking too clearly at the time that this happened, based on her comments and actions. So, as far as the actual intent, I'm not even convinced that she was capable of forming an intent at that point. But I'm not making that as a probable cause argument or anything like that. But I would ask the court to consider it for purposes of bond. I can call her father. I can call her husband. They're not local, and maybe they can come up with a little bit amount of money.
Does she have any priors, or is this the first thing?
Your Honor, I think there were priors out of Ohio. I'd have to check. Really, my greatest concern is she has, from what I can tell, no ties to the community. Could you go on JAS? I don't know if it's just a drug issue, if there's mental health issues here as well. It would mean from some of her comments. Tedder, T-E-D-D-E-R. But I do have concerns about her future appearance in court for the NCIC. Yeah, I'm showing out of Ohio. She had a DUI in the past. She had all the way down. All right, go up slowly. Go. There's a domestic violence arrest in February of this year. I don't know what's going on with that.
Miss Tedder, do you live in South Florida?
No, I'm from Ohio. I'm trying to get back to a treatment facility in Ohio, but I have no money and no phone, so it's been very complicated.
Did you have an offer on your case?
Count 2 is a felony.
Okay. All right. Well, what is your recommendation for a bond?
Your Honor, I'd be recommending a $500 bond on count 2.
And what about 1?
I'm fine with no bond necessary.
Mr. Reedy?
Well, I know she doesn't have any money, so my initial request is it would be pretrial release. If the court's not inclined to do that, I'll see if her family can come up with $500 to get her out.
Okay, I'll set the bond at $500. Thank you. Good luck to you, man.
I'll make some calls for you. Good luck.
Thank you. To see if you can find treatment in Ohio. Thanks.
Well, you know, I don't have an objection if you want me to recommend her to SAP. If you think she might be in for 30 days trying to get her bond.
What is it called?
There's a drug program in the jail if you're interested.
Sure,
it wouldn't hurt. It wouldn't prevent you from leaving if you're bonded out. But if you're not going to be able to bond out, maybe you get some help while you're in there.
Yeah, I would like to stay busy while I'm in here.
All right. Okay, I'll ask the judge to sign an order to that effect. Thank you for making that suggestion, Your Honor.
Okay, thank you.
All right, Amy, good luck.
Okay, let's go to the the next docket. Yeah.
That means you only have Mr. Houston and Mr. Pringle?
I don't. Okay. Okay, so you're going to that docket. Okay. Let's go to Derek Camarucci.
No problem, Your Honor.
Okay. State, did you file the information?
Your Honor, this is a second look. He was just arrested the other day. Judge Brown set a $5,000 bond, I believe, on the burglary, which was of a business. I provided the court and defense counsel with a supplemental report that gives me a little more detail.
Yeah, you didn't put them in order, did you?
I didn't, well, no, I didn't know what order the court was going to be on.
I'll try to.
It's Your Honor. I think it's the top one, Your Honor. Yeah, that's it right there. The top one.
Where's his name?
If I could, I mean, it's in the body of it.
Mr. Reedy, did you have an argument?
I do, Your Honor. Mr. Camarucci's been living here in Florida for about 1 year now. From what he tells me, he does not have a stable address. He does not have any money. I believe from what he says, he's been in contact with the criminal justice system on 2 or 3 prior occasions. He's not going to be able to post a monetary bond. I'd ask the court to consider pretrial release for Mr. Camerucci. Even if he doesn't have an address, he can still call in and keep in touch with pretrial.
Okay, and state, what was your argument?
Your Honor, I would be opposing outright release to pretrial on a burglary charge, especially considering he's at large.
He has no other way to get out of jail, Judge.
And it was set at $5,000?
Yes, yes, sir.
And does he have priors?
I'm checking that right now.
Okay, I'll save you some time. I'm going to reduce the bond to $2,500.
I'm just gonna.
I reviewed the probable cause affidavit. Okay, let's go to a different order. Maybe it might be easier. Jimmy Mathis.
Conti?
Okay. Mr. Reedy, did you have an argument?
With regard to Mr. Mathis, Judge?
Yeah.
I did not have an opportunity to speak to him.
It's a motion.
It's a 30-day. Is this a 30-day?
Well, they all say ROR.
Right.
Even though the last one was not an ROR, it was.
Your Honor, for some reason they're all called that. Really, if I refer the
Go
court
ahead.
to the date of arrest. In this instance, it's a 30-day motion for release. The state has not filed an information on this case. He's entitled to an ROR in these charges.
Okay, then I will grant the motion. Congratulations, you won your motion. You're going to be released.
Yes, sir.
Keep track of your court date, Mr. Mathis. It doesn't mean the case is over. They could still file the charges, and you would have to come back to court.
Yes, sir.
Okay, good luck.
Okay, good luck to you. Scott Galamidi.
That was the case you heard out of turn before, Judge, with private counsel.
What's that?
You heard that case with private counsel earlier, out of turn.
Okay, right. Jason Terrell, page 3.
Conti again, Your Honor.
Okay, we're there.
Your Honor, the state has not filed an information at this time on this case. Defendant is entitled to ROR on these charges.
Okay, sir, you won your motion. I'm going to grant it. You'll be released. But as the defense attorney said on the last case, the case is not over. It's still pending. You still need to show up to court and resolve your matter, one way or the other. Thank you. Good luck to you.
Okay,
good luck to you. Okay. Dion Houston, page 4. Okay, Mr. Houston, is this another?
They're all second looks from here on in.
Okay. Mr. Reedy, or counsel, do you have any argument for Mr. Houston?
Judge, at this point, I didn't have a docket to know, so I think he's on a second look to reevaluate the bond situation.
He is.
He has not been able to post the bond as it's set.
State, do you have?
He does have a phone in which he could call in for standard pretrial if the court would put him on standard pretrial.
So I'm sensing he doesn't have residence.
Well, your audio went off. I don't know if that was on purpose or not, but does he have a place to live?
Well, Judge, at this time he does not, but that's why I'm asking for standard. He wouldn't necessarily need a place, but he can call in. He does have a phone that he could call in.
Okay, and what was the bond set at?
I believe it's set at $2,100. Your Honor, my request, he does have priors. 2014 possession of cocaine, 2011 burglary of a dwelling and a grand theft with a violation of probation. I'm going to be requesting if he's placed on pretrial that one, obviously condition of no alcohol or intoxicants, but that there also be random testing. So he's going to have to go in.
I'm going to ask this. Would he like to go to the SAP program?
Just the stop.
Judge, he does have an address. He could get mail.
Okay, that's not my question. I'm not inclined to change the bond. My question is to ask if he'd like to go to SAP while he waits.
I thank you, Judge, but not at this time.
Okay, I'm going to keep the bond the same. Thank you very much.
Judge, if we could have a phone order for him to access property, I think one of the issues he mentioned it had
I'll
already
grant
been
your
signed.
motion. I'll grant your motion. Thank you.
But he just has access.
All right. Ricardo Riquelme Alonso.
He's in the North Broward, Judge.
Okay. This was a second look, and counsel, do you have any argument?
I do, Your Honor. Mr. Riquelme has not been able to post the bond as previously set. He was staying at the Salvation Army. He has a bus card. He is a veteran of the U.S. Marine Corps, having received an honorable discharge in 1979. He served 3 years. He does have some physical issues with his back that concern me about the type of medical attention he might receive in the jail. He indicated to me also that he has doctor's appointments later on this month regarding those injuries, and he would like to be able to attend those appointments. He's not going to be able to make any kind of a financial bond, Your Honor. I would ask the court to consider releasing him on his own recognizance with the conditions of pretrial release.
Please, Your Honor.
And state what, sir, 1 second, I'll let you talk. I want to find out what the state is arguing. And what the bond is?
The bond is set at $1,000 on count one. Let's see.
And we can't send him to Veterans Court until after he goes to the division?
I believe so. I believe there's paperwork that has to get filled out and verified. Just checking his record, Your Honor. He has been in state prison for grand theft auto, showing his most recent was DWS habitual offender, possession of cocaine 09, aggravated assault with a deadly weapon 98, 3-year state prison. That was with the grand theft auto. Battery 95, assault 95.
Okay, you don't have to go any further back. I'm going to keep the bond the same. Thank you very much. Based on the prior.
All right, hang in there, Ricardo. We'll try and get you into Veterans Court, okay?
Devontae Hughes, page 5. Devontae Hughes?
He was bonded, Your Honor.
Oh, okay. Then we will not look again. Vivian Pringle. Vivian
Yes,
Pringle.
Your Honor. Good afternoon, sir. Good afternoon, sir.
Good afternoon. You are charged with retail theft, and you want a second look. Is there an argument, counsel?
Judge, he's been in South Florida for more than 40 years. He does have a current address that he can live at. It's his own residence. At this point, he's concerned because the home's unsecured and he doesn't have anyone that can go and do that for him, as well as anyone that can bond him out. He is employed doing painting jobs. He has some customers that are waiting to get the work done, so no income coming in at this point, and also a job as a part-time at the 15th Street Fisheries. So he is employed, although he doesn't have any money in the bank or the ability to bond out. I'd ask the court to ROR him. Pre-trial.
Okay, what was the bond?
Judge Brown kept the $1,000 bond in place. I believe it was based on his criminal history. 2011, possession of firearm by convicted felon and discharging a firearm in public. He was sentenced to 41.5 months in state prison. Theft, 2010. Fleeing and eluding with an enhanced DUI in 09, VOP, 41.5 months state prison. Violation of a domestic violence injunction, 99. Assault, 98.
Yeah, correctly, the most recent was 2000, which was still 2011, which was still some time ago.
Well, with 3.5 years, sentenced to 3.5 years state prison.
Okay. I am going to not change the bond and just leave it the way it is. Okay, thank you very much. I think that's everybody on that.
Do we have an order for him to access his phone, please?
Granted. She asked for a phone. Okay, do we have Eddie Rancher?
Your Honor, we resolved that this morning.
Okay.
What's that? No, we just have Dwandell Brown. Rancher,
No.
second look on a misdemeanor.
What about? Okay, that was done. And we did the ROR docket, right? We just did that. Okay, so we just have this one case left, it appears. What is the number? Can you hand it to me, or do you want to say it on the record? Yeah, I was going to do that. I just didn't know if you wanted it on the record.
Free advertising.
Okay, well.
Is that 954?
I think we go with the bad.
605.
Okay, Mr. Dwandell Levon Brown, you could come up. I'm going to call your attorney.
Yeah, this is Bill.
Hello, this is Judge Gottlieb. We're at first appearance. Your client is Dwandell Levon Brown.
Yes, Judge. Thanks for letting me appear by phone.
Okay, and I do find probable cause after reviewing the probable cause affidavit. State, do you have any priors or recommendations?
Yes, Your Honor. I'm going to be recommending a $5,000 bond on count 1 in light of the no bond holds for charges 4 and 5, the burglary, conveyance, and criminal mischief. Additionally, he has prior convictions, 09, false imprisonment and felony battery due to priors. He violated probation, was sentenced to 13 months state prison. 09, possession of controlled substance, VOP, 13 months state prison. 03, battery on a law enforcement officer with a violation of probation.
Yeah, and you see there, Judge, there's nothing to do with guns or anything like that. It's my understanding the gun was not found on him. The car is used by multiple people, and I believe his significant other has a permit, and that is her gun. So I don't believe that charge will be filed. And in light of the no bond hold, which I know you can't touch, and again, Dwondell, if you can hear me, Judge Gottlieb can do nothing with the no bond hold. That's up to Judge Siegel. But my point is, Judge, if you could keep that bond on the gun charge down to maybe $1,500, I think that would be reasonable in light of all the circumstances.
Okay, based on the priors and the probable cause affidavit, I'm going to set the bond at $5,000. I'm going to keep the bond at $1,000 on count 2. The no bond holds, as you said, I can't do anything about, and the speeding, that is an infraction. Okay? Thank you very much.
All right, thanks, Judge.
Have a great day. Bye. I think we are done, unless somebody has something to offer. Okay.
Nothing to offer.
Have a great day.
Thank you, Judge. Always a pleasure.